Good morning and welcome to this subcommittee meeting of the Licensing Board on today, the 5th of June 2024. I'm Councillor Lawrence Williams, and to my right is
Councillor Alistair Keddy.
And Councillor Brian Castle.
The first item on the agenda is the election of a chair. Would somebody like to nominate chair?
I would like to nominate Councillor Lawrence Williams as chair.
Thank you.
And I'd like to second Lawrence Williams as chair, please.
Thank you. Can we please deal with housekeeping? I'll ask the Democratic Services Officer to read anything.
Certainly. Thank you, Chair. Please note that this meeting is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcast by members of the public, although ultimate discretion for this matter lies with the Chair in case of disruption. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point at the War Memorial in the gardens opposite the front of this building in Bourne Avenue. Finally, please ensure background noise is kept to a minimum and mobile phones and other devices are turned off or switched to silent for the duration of the meeting. For those in the room, this includes turning off microphones and turning the volume down completely on your laptops. Thank you.
Thank you. I wonder if you wouldn't mind giving any apologies.
None received, thank you.
Thank you. Declarations of interest. I'll ask each member in turn if they've got any declarations of interest. I don't.
I have no declarations of interest.
Thank you.
Now, I also have no declaration of interest.
Thank you. The protocol for speaking. The protocol for speaking at meetings of the Licensing Subcommittee is included in the agenda sheet for this meeting. So that brings us to item 5. An application has been received for the renewal of a sexual entertainment venue licence for the premises known as Wiggle, 159 Old Christchurch Road, Bournemouth, to permit relevant entertainment to continue for a further 12-month period. This matter is brought before the Licensing Committee for determination. I'll now ask each participant to introduce themselves and state their role, starting with myself, Councillor Lawrence Williams. I'm the member for Littledown and Iford.
I am Councillor Alistair Keddy, member for Queen's Park and Charminster.
And I'm Councillor Brian Castle, member for Muscliffe and Stroughton Park. Thank you.
Thank you. We've got Councillor Adrian Chaplin-Law as a reserve member, but he won't be required to participate as we're all present. But he may, if he wishes, observe for training purposes.
Good morning. I'm Sarah Rogers, a Principal Licensing Officer, BCP Council.
Good morning, I'm Linda Cole. I'm the legal advisor to the subcommittee this morning.
Good morning, I'm Michelle Cutler and I'm the clerk to the subcommittee. Thank you.
Finally, please may I remind all parties speaking not to repeat the information which they've already given in writing, but to expand on their written representations. All questions are to be asked through the chair, and there will be no cross-examination of parties. I now ask the licensing officer to present the report. Yes, I probably should, shouldn't I? I should have turned the page in. Yes, I'd like, if I may, to ask everybody to introduce themselves, starting with the applicants.
Roger, Managing Director at Wiggle.
Thank you.
I'm Taran Ojala, the General Manager for Wiggle.
Thank you. And the objector.
I'm Susan Stockwell, the objector.
Thank you. Before I run through the procedure, which I should have done earlier, please may I check that everyone has been given notice of their intention to speak, have been identified, and any person who wishes to withdraw a representation or wishes not to speak has also been identified. If there are no comments, I'll take this as correct. Okay. I'll now explain the proposed procedure and order of speaking for the hearing as follows. The licensing officer will present the report. The objector will speak first. Questions of the objector by members of the committee, subcommittee to go first. The applicant will then make their representations. Questions of the applicant by members of the subcommittee to go first. All parties will then be given the opportunity to sum up with the party who spoke last to go first. The hearing will then conclude. The subcommittee will deliberate in private with the legal advisor and the clerk present. Where possible, notification of the subcommittee's decision will be given within a period of 5 working days, beginning with the day or the last day on which the hearing was held. The notification of the decision will include information on the right of appeal as appropriate. I now ask all parties to confirm their agreement on the proposed procedure or make representations. Firstly, with the applicants. Do you confirm agreement with that?
Yes, we do.
Thank you. Mrs. Stockwell.
Yes, Chair.
Thank you. Sarah?
Yes, thank you.
And finally, Linda Cole.
Yes, Chair.
Thank you. Right, now we'll go to the page I was on before. Finally, can I please remind all parties speaking not to repeat information that they've already given in writing, but to expand on their written representations. All questions are to be asked through the chair and there will be no cross-examination of parties. Now ask the licensing officer to present the report.
Thank you. Application is made by Well Hot Limited for the renewal of the sex establishment licence held at 159 Old Christchurch Road for a further 12-month period. The premises have been operating as an adult lap dancing club for the past 18 years, since they took over in 2006, when at that time the premises were operating as a cabaret restaurant. They've had the benefit of a sexual entertainment venue licence, permitting the live performance of nudity following new legislation which came into effect in April 2010. The application made complies with the relevant legislation and the necessary site and newspaper notices were published in accordance with that. As a result, one objection was received. There have not been any complaints received during the last 12 months and no need for the licensing officers to visit the premises to ensure any compliance. No objections were received from any other responsible authorities which are identified under the Licensing Act, who were also consulted. A reference has been made in Mrs. Stockwell's objection to our sex establishment policy document, but please note we do not have a current policy following the quashing of it by judicial review. Thank you.
Thank you very much indeed, Sarah. Mrs. Stockwell, I would like you, if you wouldn't mind, to state your case now. Thank you.
Thank you, Chair. Could I just start by asking if I'm able to question the officer's report? I wasn't quite clear from the procedure. It's just on 2 points.
Yeah, you can.
Yes, you can. Yes, you can.
Thank you. Firstly, that and I've raised it in another hearing, that the officer's written report, suggests that there is a presumption in favour of licensing for this form of licence. That certainly is the case for the 2003 Act licences. But on my understanding, it's not the case for this form of licensing for sex establishments. I have scoured the legislation and I couldn't find it there. Yes, thank you.
So it's not set out, certainly not set out in the 82 Miscellaneous Provisions Act that deals with sex establishments, but generally, as a whole, through case law, the idea of licensing and the decisions being made, and it's like a quasi-judicial nature. There is generally a presumption to grant any application unless there's a need not to grant it, because the decision's being made not in a court of law, it's being made by local people in their job, and the decision making process for this type of application has, in the legislation, it comes down to the local authority. But generally the whole idea with licensing, it's all about public safety, risk assessments, and also their common knowledge and what information is brought to them by, you know, people that may be in the know. For, you know, we would take information from police officers. I mean, you have to consult with police officers anyway with sexual establishment licensing, but generally we would go as far as any responsible authorities, just to sort of gather that information in.
Yes, I don't accept that because it's been specifically included in the 2003 Act, and if there were general case law, there would be no need to do that.
Well, that's
so I'm happy to go away and look at the case law, which I haven't been able to find.
Would you proceed? Thank you.
Thank you. So, as I understand it, Chair, the procedure here is unlike other licensing hearings that I don't read my objection out to you, but I just expand on it, which leaves me rather at a loss. I can just do a sort of whistle-stop tour of it, and perhaps you could stop me if you think I'm repeating myself.
Well, we've all had the opportunity to read
Yes,
it, so
exactly.
there's no need to repeat it. But if you've got anything additional you'd like to add, this is the time to do it.
Well, since the applicant's response to my objection came in, I think I can possibly mention a suitability head, which is that I would suggest, and this is expanding on suitability, that the quashed policy on licensing of sex establishments is still relevant because it was adopted by our full council. So although it's not a policy, it doesn't exist anymore, the fact that full council adopted it at all suggests that the contents are reasonable, and therefore if you look at what is suggested as being the right way to look at suitability, as in honesty and an understanding of the licence itself, that's a reasonable thing to do for you, that the prospect of a judicial review on the basis that you've behaved unreasonably by considering how well the applicant complies with regulations in other areas outside of licensing is reasonable, because your colleagues in the council in the previous administration did say that the applicant needed to be able to demonstrate that they could understand the license well enough to be able to comply with it. And the reason I've brought up in my objection various regulatory matters outside of licensing and inside of, including the previous breaches that have been brought to the attention of your committee and your officers, that's an indication of unsuitability. In addition, the mention of honesty, well, honesty is as honesty does. There's chancing your arm, there's taking a few risks, and there are things that might be to do with not understanding. But in the, as I would be repeating myself if I mentioned what happened in Weymouth, of telling the committee that the locals are quite happy. But
yeah, you will be repeating yourself.
Yes, I won't carry on then. I'm obliged, Chair. The location, as the applicant has mentioned, this is something that's been brought up previously, and frankly, as long as there's no policy adopted which says it's absolutely fine to have a strip club or other sex establishment in the locations specified by the policy that was adopted and then quashed, then I think you're still going to carry on seeing me at licensing hearings, because when a strip club is operating in an area which conflicts with the policy that was adopted, then that means that if you choose to refuse on location, from which there's no appeal, then you can do that. You can do that without fear of a judicial review because it's perfectly reasonable to follow the guidance that was adopted by full council. It wasn't just a tiny little committee. So if you do go for the reasons that are in that policy, you can't just say because of the policy, you have to really explain yourself as we consider this reasonable.
But as you've said yourself, there is no policy. So
no, there is no policy,
So-
but there is the fact that a policy was adopted, even if it's been quashed, so that you can't.
well,
The quashing doesn't mean that none of this is a relevant issue on location. It just means you can't say, and the policy says, next question.
we should probably move on.
Yes, okay. So as I've said, next door you've got vulnerable people using the services in Trinity House, and on the other side next door are your own tenants in the Citrus building because you are BCP Council and they are your tenants in long leaseholders for the residential, commercial tenants for the restaurant, and they are right next door with the only bus stop for that development, which was supposed to be encouraging on your policies, use of buses. The only bus stop is right near the applicant's premises, and you've already heard ad infinitum about the complaints of harassment of women from people coming out of the strip club. So I would say that that location is perfectly reasonable to refuse on. If I could take you on a whistle-stop tour of what, I'm sure your officers will advise you on this anyway, of what could be appealed on. So suitability, if you refuse on grounds of suitability, as I've urged you to do, the applicant could have grounds for appeal on that. If my application had included unsuitability of the premises, which it hasn't, because as I say, I've still had no sight of a plan that's regulatory compliant. I mean, your officer has sent me, best available as far as I'm aware, so it doesn't include that, but there would be an appeal if you decide to adjourn until we get a plan so that I can take a view on whether or not that's a suitable building. Location, though, no appeal available. However, if the applicant were to launch or I were to launch a judicial review, there are also relevant factors to consider. I should say at this point, because I don't want to be making empty threats at all, especially when there are a few like this being thrown around, not in these proceedings, but at your council. I am certainly not in funds and I don't have any immediate means to obtain funds or any means at all to bring judicial review proceedings. So I'm putting that out there because I don't think it's good style at all, personally, or for this to say, and I'm going to do a judicial review because that, I'm not saying I'm not, because who knows what's around the corner, but it's certainly not something that I've got up my sleeve to be threatening. But in any event, though, I will say that risks of judicial review can come up if you've got any sort of administrative irregularity. And I would suggest, although it doesn't quite fit previous instance of administrative irregularity that I'm aware of, that the fact that I haven't had sight of a regulatory compliant plan of the building is an administrative irregularity because it doesn't allow you to consider properly whether this building is suitable, and it doesn't allow me to make any representation. Now, the plan, as your officers has rightly said, and is indicating to me quite clearly, is not required under the legislation for licensing this premises for sexual entertainment. However, it is required for a licensing application for alcohol and for the dancing that goes on under the 2003 Act. And I suspect, although I don't know for sure, that the reason there is no plan required for sexual entertainment venue licensing applications is because you would almost always, unless there was such a thing as a no alcohol sexual entertainment venue have a plan already filed and available on public records from which you can make a judgment on whether those premises are suitable. So I say that is an irregularity. And I also say that details of breaches which you can use as part of your assessment on the suitability of the applicant for running an SCV. Details of those breaches, I say that they should be made available to the public, certainly under the Openness of Local Government Bodies regulations in 2014. And the fact that those haven't been made available to me as the public means that this hearing can't proceed lawfully, because that is a gap in what should be done by way administration, that should be made available publicly. The plan of the premises in all its glory in accordance with the regulations, and details of previous breaches, because how can you hear public representations on the suitability of the applicant if the public are not able to see details of what breaches have happened previously?
Can I just stop you
Yes,
at
of
that
course.
point and ask Sarah Rogers to comment?
Yes, certainly. The plan that you refer to is a public document and it is attached to the premises licence, which is issued under the Licensing Act. And I have a copy here and it's readily available on request. I've sent you the plans I have, and the only plans I have, and I've sent them to you a couple of times now. I have no other plan to give you apart from the approved plan that is attached to the licence. So you've had that information. With regard to the breaches you refer to, there have not been any breaches. We did have breaches a few renewals ago, a couple of years ago, which were identified and dealt with sufficiently by the applicant by way of minor variation to rectify the issues that were raised. And the plan was approved and updated accordingly. There are no current breaches available to disclose to anybody that I am aware of.
Thank you, Sarah. Can you now move on and proceed?
Chair, can I just be clear that I'm not allowed to counter what's just been said
Well,
then?
it's not a debate.
Yes, I see.
Thank you. Have you got details of breaches that you can give us?
Well, no, because they haven't. Yeah, well, yes, I'm not talking about breaches in the last year. These are breaches
Well,
that occurred.
forgive me for interrupting, but it's the last year that we're looking at.
Well, this brings me on actually to what needs to be considered as relevant. And I say that what is relevant is not just what happened in the last year, but actually things that happened before the last year are also relevant and that they must be considered.
But this is an application, a fresh application that we're considering, and there is no breaches that we're aware of. So
no, but I beg your pardon, Chair, but last year at the hearing last year, the fact that there had been breaches and the nature of those breaches was something that I, as a member of the public, was not aware of until after the hearing and the decision had been made, when I met people from the Office of the Police Commissioner who told me that the police had made objections and that was at their instigation. And as a result of that, I approached your officers for details of those breaches, and I was sent, I've got the email trail of the conversation about the breaches. And yes, your officer then made a judgment and was able to approve it was the minor variation that was given prior to the annual licensing. Now, what I take issue with is that when I've asked for details of what those breaches were under the Openness of Local Government regulations, they haven't been made available to me. And I say that's an administrative irregularity, because I say that relevant factors are not just whether there have been any breaches since the last hearing, but basically anything that is relevant to the suitability that's taken place since the applicant was licensed, and where he's licensed in other areas for other premises, and that's why they're included. But it's entirely a matter for you, Chair, and your
Thank you.
as to the
Well,
weight you give them.
We've noted your comments and we'll take them on board. Would you like to continue or have you finished?
I don't think there really is anything else apart from to very much encourage you, if you have any shred of doubt
Well, you
about
can sum up
your ability to ability to refuse this license, please, ask me now. Don't let me read it in the decision notice that something was considered which I haven't addressed you on.
Okay, thank you. Members, do you have questions for Mrs. Stockwell?
I do not at this time.
Okay.
No, I don't have anything at the moment.
And I've interrupted you sufficiently to thank you. I'm going to. Applicants, do you have questions for Mrs. Stockwell?
Is this where we ask questions? Is it where we add on to our statements?
No, you can ask questions.
Really just about the pattern of objections. It seems more of a personal crusade as a single individual. Of course, the public are entitled to raise objections. However, you seem to have a very well vested interest against us at Weymouth, Southampton and Bournemouth to use the public's resources. Do you feel it's a necessary expenditure of these resources to bring us to committee every single year, not just us, For Your Eyes Only, Club Temptation, simplypleasure.com, anybody with any sexual entertainment venue license, sex shop license, anything? Do you feel it's a necessary expenditure of these resources?
Yes, I have considered that very carefully, and I do consider it an appropriate spending of resources. And I would just caution that that's not a relevant factor, so watch out for judicial review.
We're just about to jump in.
Yes.
Sorry.
As far as being a personal crusade, I think you've already demonstrated that this is nothing personal against the applicants. This is something where I am concerned that the licensing policies and practices locally haven't really been in the interests of Bournemouth Town Centre and my use of it.
Do you have any more questions? I would caution you to be a little careful with what you ask.
On that basis, probably not.
Yeah, I understand. Thank you. Right, so moving on. The applicant, would you like to now make your representations?
Yes, of course, you've got my written response enclosed, and I believe it covers most of Susan's objections detailed. The only thing that I didn't cover was the additional response, which I saw online, so I just wanted to cover those just for completeness. The venue closer in Altrincham, that's how it's pronounced. I see no relevance to that. It's a venue located 243 miles away. So what relevance that has to our renewal application, I really question. On the website mentioning performer safety, we do indeed have a page on our website dedicated to performer safety. We take pride in the steps that we take above and beyond our licensing requirements to keep our performers safe, which is something any workplace should strive for. It's not an admission of guilt. Any workplace should strive to have a safe, wholesome work environment for their staff members. On pricing policy, the objection mentions tipping and no sizes of alcohol bottles. I'm not aware of any provision in the Licensing Act that says a customer is unable to tip a member of bar staff or a dancer. And on the sizes of alcoholic bottles, they are included on the menu page of our website on all menus at the premises. And of course, we have the Weights and Measures Act notices displayed inside of the premises. On workplace checks, condition 60 of our license states that we must keep written details of dancers. Within this, we include the right to work check, as we conduct this on all persons engaged at our premises. Engaging illegal workers faces a 5-year prison sentence, and a £60,000 fine per person. So we are very well motivated to avoid doing that already. I don't think it's something that needs to be included in the licence, as it's already regulated by the Home Office. And finally, on Susan's comments at the end of it on the cab rank rule, I see no reason why the objector should have a say in our business's operations. It frankly is not a licensing matter and has nothing to do with the 4 licensing objectives. If it is something our objector feels so strongly about, then I would suggest she opens her own SEB premises and keeps her consultancy services to herself.
Members, do you have questions of the applicant?
No, not at all. Not at all.
Not at this time. I would just note that the 4 licensing objectives, I believe, are on the 2003 premises licensing rather than SEV licensing.
Yes.
But that's just a point of clarity.
Yeah.
Thank you.
Well spotted. Mrs. Stockwell, do you have any questions of the applicant?
Sorry, Chair. It's not exactly a question, but just really to state that Altrincham and this local authority are under the same law, so it's relevant there. The prices on the website, I have looked several times and I can't personally find them, but that may be a fault on my part. I can't see any prices on the website for the private dances. So again, I'm not sure that really that's clear pricing policy. As far as illegal workers go, my understanding, which I haven't got chapter and verse of the law at my fingertips, so it may be that the applicant is correct, is that the fining for illegal workers is for employees. So somebody working there not as an employee but as a self-employed person would not generate that sort of offence being committed, and that's why I've suggested it as part of the licence. The Company's House documentation filed for Well Hot, and I'm not quite sure how many premises that covers. It may be just the Wiggle one in Bournemouth, for all I know. I really can't remember which one's licensed. States 9 employees. So I would suggest that that leaves a balance of other people working on the premises. That
Is there a question in?
Oh yes. Do you have more than 9 people working at Wiggle Bournemouth who might not be employees but self-employed, as is the usual pattern in your industry?
It's approximately 9 or so people. Of course, the Company's House document is only updated annually, so some do come, some do go.
Thank you.
Thank you.
That's all the questions.
Okay. Sarah, do you have any questions?
No, I don't. Thank you.
Nor do I. Thank you. That brings us to summing up, and if you wouldn't mind summing up as the applicant, please.
Not really an awful lot more to say, really. We've really discussed this in detail over a number of years now, and I'm sure that we will continue to do so for another few years. Of course, the committee, if you do have any questions for us, we're more than welcome to answer them. On the notes of right to work checks, I do have those all securely stored on a database on my laptop. So if there were any questions, any queries, I'm more than happy to provide that to you in a statement or any document or to any licensing officers upon their request. Thank you.
Thank you. And Mrs. Stockwell, can we have a brief summing up?
Thank you. I think really all I want to say by summing up is think of Bournemouth. Think of what the effect of having 3 strip clubs in close proximity to each other is having on the centre of Bournemouth, in contrast to the outlying areas, which are thriving. Thank you.
Thank you very much indeed. That will now conclude the hearing. The subcommittee will deliberate in private with our legal advisor and clerk present. and where possible, the notification of the subcommittee's decision be given within a period of 5 working days, beginning with the day or the last day of which the hearing was held. Notification of the decision will include information about the right of appeal as appropriate. I'll now ask all parties to confirm their agreement and we'll close the meeting. Thank you.
I can only reiterate there will be a right to appeal to any decision that is made by the subcommittee today. That the details of that will be in the decision letter, which you'll get as applicant, you'll get as objector, and needs to be made to the Dorset Magistrates Court and within 21 days of receiving the written decision. So we will endeavour to get the decision to you within 5 working days. There isn't a statutory time frame for it as there is in the Licensing Act, but that certainly will be our aim. Okay.
If you're happy.
Yes, thank you. That does conclude the meeting. Thank you.